Fantastic question. If you don't succeed, do you have a pathway to force majeure depending on the facts? If you don't succeed at general average. So it's the ship owner who declares general average, and they have to meet all the requirements for it to be a valid general average, which you can then dispute. And so I think what this is about claims. So if we're talking about cargo interests, can you claim force majeure if they've lost the containers overboard? You don't need to claim force majeure because force majeure is the frustration of the contract, but there is a provision in the contract for loss to cargo. So if we take a step back, force majeure is, depending on the jurisdiction, normally actually only defined in your contracts. It's not necessarily statutorily defined, but again, depending on your jurisdiction. So force majeure will come down to the contractual definition. So if you are the cargo owner and you are listed on the ocean carrier's bill of lading terms and conditions, and your container goes overboard, then there is already an internal mechanism within that contract for how you claim. There is a limitation of liability though. If you are an end consumer, so you're the ultimate consignee, and you have a contract with, say, the freight forwarder who's listed on the ocean carrier's bill of lading and that container's gone overboard, you're not directly contractually involved in that arrangement, even though you might own the goods under your Incoterms sale by sale contract, for example. But you don't have privity of contract, meaning you're a third party and you have no enforceable rights. So then it's determined on what the arrangement is between the freight forwarder and yourself if you own the cargo that's in the container that went overboard, but you're not listed on the contracts. So does the freight forwarder have what we term a house bill, which in theory, at its optimized usage, is a back-to-back contract. So you have the ocean carrier's bill of lading, what we call the master bill, and then we have the house bill, which is cut. So the master is ocean carrier to listed consignee and listed shipper, and then listed consignee might be a freight forwarder, and they'll cut what we call a house bill. In practice, a house bill can be anything from really good contractual issues versus a really glorified pretty tracking slip, which does not much. In that case, you may be wading into the ye olde concept of bailment and tort of negligence, which is highly problematic. Don't do that to yourself. Check you've got good T's and C's. Or even further downstream in the contracting, it may be that you needed that so you could fulfill, say, something on a retail storefront that they've done a catalog for. And so then you've got more downstream contracting risks, and then frustration might come into that then. But it's so far removed, you might have issues of foreseeability and nexus of damage.